Hi, my name is Santangelo. I'm the Executive Director of NYS Fair Housing. This training video is going to be about reasonable accommodations and modifications under fair housing laws. Funding for this training was provided in part by the U.S. Department of Housing and Urban Development. NYS Fair Housing is a nonprofit located in Syracuse, New York, that's dedicated to eliminating housing discrimination and working to promote open communities. What we do is investigate complaints of housing discrimination. We conduct undercover testing as part of that investigation. We conduct advocacy and counseling for individuals whose rights are being violated in their housing. And we provide legal representation to victims of discrimination. We also conduct education and outreach on fair housing rights and responsibilities, as well as conduct research and policy advocacy to promote housing opportunity. Nothing presented in this presentation, either verbally or in writing, is legal advice. If you need legal advice, please consult an attorney. Under federal and New York State fair housing laws, housing providers cannot deny or refuse to make a reasonable accommodation or permit a reasonable modification for individuals with disabilities. In terms of who has to comply with these laws, fair housing laws apply to anyone involved in the provision of housing. So that includes property owners, managers, staff, public housing authorities, real estate agents, and in some cases, state and local governments. There's a limited number of properties that are exempt under fair housing laws in New York State. And that includes owner-occupied two-family houses unless the owner uses an agent to rent or manage the property. Discriminatory advertising or discriminatory statements, however, are never exempt. They are always illegal. So under fair housing laws, a reasonable accommodation is a change, exception, or adjustment in the normal rules, policies, practices, or services that are offered by a housing provider to allow a person with disabilities the full use and enjoyment of the dwelling and the related facilities. Some common examples of reasonable accommodations include assistance animals in no-pet housing, assigned parking spaces when parking is normally first come, first serve, transferring units for a disability-related need, changes in communication methods for individuals who may have a visual or hearing impairment, trash pickup when an individual is unable to remove trash from their property themselves or their apartment themselves, snow removal, or leniency for behavior that violates a lease, such as adjusting the due date for individuals who have a disability payment that comes in after the first of the month. Reasonable modifications are structural changes or structural modifications that are made to, again, allow a person with a disability the full use and enjoyment of their dwelling and the related facilities. Common examples of reasonable modifications include things like ramps or grab bars, sidewalks, or maybe flashing smoke alarms or doorbells for individuals with hearing impairments. For reasonable modifications in federally subsidized housing, such as public housing or other HUD subsidized housing, the housing provider is responsible for the costs of all modifications. In private housing, the tenant is responsible for the costs of modifications within their unit, while the landlord is responsible for paying for some modifications to common areas. Under fair housing laws, disability refers to any person who has a physical or mental impairment that substantially limits one or more major life activity, has a record of having such an impairment, or is regarded as having such an impairment. Common examples include mobility impairments, visual or hearing impairments, major diseases, mental illness, depression, anxiety, PTSD, and autism. The more difficult thing in determining reasonable accommodations and modifications is what is considered reasonable. Both HUD and the U.S. Department of Justice and a number of cases have held that what is considered reasonable are changes that do not impose an undue financial and administrative burden on the housing provider or that would fundamentally alter the housing provider's operations. This takes into account what the resources are of the housing provider, what is the cost of the accommodation or modification, what is the benefit to the person requesting it, and are there other less expensive alternative accommodations or modifications that may work for the individual's need. Insufficient reasons for denying an accommodation or modification that we hear often in our cases are aesthetics, that everyone will want the same thing, or that it may be not fair to others. The goal of an accommodation or modification is to allow the person with a disability the same enjoyment of the dwelling that individuals without disabilities have. When someone is seeking a reasonable accommodation or modification, the request does not have to be made in a particular way. The tenant just has to make their needs known to the housing provider. We, of course, recommend that requests be made in writing and that the individual ask for a response from their housing provider in writing as well. A housing provider may have a particular form or process they use for tenants to request reasonable accommodations or modifications, but they cannot require that the tenant use that form or process. If a person's disability is not obvious, they should be prepared to provide information from a third party that verifies that they meet the Fair Housing Act's definition of disability, that describes what the needed accommodation is, and that shows the relationship between the person's disability and the need for the requested accommodation. The verification that they provide does not need to come from a doctor, but should come from somebody who is familiar with the disability and the need. A housing provider cannot ask for information about the individual's diagnosis or other treatment that they have pursued, including asking an individual about medications they are taking or have taken to treat that disability. A housing provider cannot refuse to engage in a negotiation for an accommodation or modification. An undue delay in considering an accommodation or modification may also be considered a failure to provide the accommodation or modification. They should act quickly as soon as the needs of their tenants are known to address those tenants' needs. A housing provider can also not charge additional fees as a condition of granting the accommodation. This includes pet fees and pet deposits for assistance animals, parking fees, or transfer fees if an individual needs to switch units for a disability-related need. They also cannot reword the fee and call it something different, such as an administrative fee. Housing provider can also not place excessive restrictions related to the accommodation or modification. That includes size and breed restrictions for assistance animals. They can place reasonable restrictions, like leashing or picking up after the animal, or perhaps requiring a rabies vaccine. If you need more information about requesting a reasonable accommodation or modification, please contact CNY Fair Housing, HUD, or your local fair housing organization. Thank you.